Hi everyone, and welcome to video 4.1.7 for the Legal Studies Guy. Really punching our way through area of study 4.1 at the moment. Only 3 more videos to go after this one. Quick quote from Robert Kiyosaki. Don't let the fear of losing be greater than the excitement of winning. And this is a common, a common challenge I see with people at all ages, but particularly young people, is the idea that sometimes it's safer, both in terms of your standing within the community and society and your friendship groups, but just safer personally within yourself to not try, because if you don't try, you don't lose. If you don't try, you don't fail. And as a result, that's a little more comfortable than actually putting yourself out there and giving yourself the chance of winning. So this would be just that moment, with a term to go. If you're watching this throughout the year, you're probably around about the mid-year holidays, to really just think about, okay, I've got a term left. I really want to put myself out there, put my best foot forward over the next 3 to 4 months and give myself a chance of winning this year 12 battle. And winning's individual for everyone, whatever that looks like for you, but actually give yourself the best chance to do what you're capable of doing, rather than sitting back and going, you know what, maybe if I try and things don't go as well, I won't feel good, so I just won't try. Because the joy should come from hopefully the process. Actually, the process of trying to do the right thing and trying to perform well is where you should hopefully be able to find that happiness. So, without getting too deep, we'll get into what we need to actually get into today, and this is statutory interpretation, and we're going to look at the reasons. Sorry, get back on there. We're going to look at the reasons and then the effects. So just 2 main slides. What are the reasons for statutory interpretation and what are the effects of it? Key skill is a discussion skill, which I'll unpack a little bit. We don't really need to cover until a later video. So ultimately at the end of this, you're going to be able to have a conversation with someone and say what statutory interpretation is, why we need it, and probably adding on the end of that as well, what impact it has moving forward. So really quickly, hopefully this is stuff you've carried over from year 11, but if you haven't done year 11, you've picked up as sort of through your orientation, is what role the courts play in society. Fundamentally, we know that courts exist to resolve disputes between people or between people and businesses, corporations, or particularly in the aspect of criminal law between the government or the state and the individual who's breached society's guidelines. And that's primarily what the courts are there to do. They'll consider the facts, the evidence, they'll apply the law, might have a jury involved, or it might be a judge who then just makes a decision on whether someone's actions are lawful or unlawful, whether someone is liable or not liable. But as part of this, we know that there are occasions when courts also then make law. So it's a secondary role, but sometimes through the process of resolving those disputes, courts actually create laws. So sometimes courts need to resolve disputes in areas that aren't covered by any laws. And this is where whatever decision the court makes will then become law in its own right, until Parliament addresses the situation, if they ever do. And this sort of harks back to, so this is what we call common law. And this harks back to, the origins of our legal system, which is back in, old England, 1,000 years ago, when there were no, apart from the king making some laws, generally speaking, the king's judges went out and just resolved disputes as they arose, and then whatever decision they made would be made in an ongoing fashion. That's sort of how law was made originally. So if there are ever situations that come before a judge that aren't covered by any statutes by Parliament, the decision that courts make then becomes a law, if that makes sense. So the primary role is still resolving the disputes, but then sometimes as a result of resolving a dispute, courts will make common law. But courts also have a role of applying acts of Parliament, applying statutes to the situations there are in front of them. And this is what we call statutory interpretation, which is what we're going to unpack today. And that is a form of lawmaking as well. So Statutory interpretation, it's implied in the name. We're talking about statutes, and we know, hopefully, that statutes are acts of Parliament. So statutes equal laws. So courts will look at the law that Parliament has made, and we know interpreting something, to interpret, imagine you're interpreting a different language, or you're interpreting a poem, for example. You might have to do that in English, or you might have to interpret a text in English. And interpretation is about giving meaning. So when we talk about statutory interpretation, we're talking about courts giving meaning to statutes or giving meaning to laws. And I'm going to give you some reasons why we have to do this. But statutory interpretation is that process where judges take the words of an act of Parliament, apply it to the case in front of them, because remember, primarily that's what courts are doing. They're resolving disputes. So they take the words of Parliament and they apply it to the case in front of them. And sometimes, as part of that, they need to give greater meaning to the words, because the words might be incomplete. The words might be too vague. The words might be too general. The words might have been made so long ago that they're not adequately prepared for future circumstances. So these are starting to unpack some of the reasons why judges need to give meaning to laws. So let's look at some reasons why. And I've included this picture for a very specific reason. I'm sure some of you have heard of this before, this case called Dang v. Tiroler, or as it's more commonly known, the studded belt case. So our first reason for statutory interpretation, so for giving meaning to laws, is that laws are drafted in broad and general terms. So what that means is Parliament is trying to make a law to cover as many situations as possible. They can't be hyper specific. They can't say, hey, you can't do this very specific thing at this time, at this date, with all of these caveats in there. Parliament just has to be like, hey, here's this broad thing you can't do, so that it can cover a wide range of situations. This is particularly evident in what's called this studded belt case, where Parliament had what is seemingly a very appropriate law around the regulation of weapons. And basically, the law said it's an offence, it's illegal, it's against the law to, possess, carry a regulated weapon without a lawful excuse. Makes sense? Hey, if you carry around a weapon without a lawful excuse, you've committed an offence. A little bit of separation of powers in this. That's the law made by Parliament. And basically, the government of the day, can't remember exactly what year this is, but I've linked the case to you later on. They gave some regulations about how they wanted that enforced. So they said, hey, this is how you enforce it. And one of the things that they wanted to be considered a regulated weapon and enforced was clothing like this. So any clothing that had raised studs. And as a result, there was a guy, he was a young guy, he was 20, he had just bought a belt like this from the Dandenong markets, and I'll link you the case later on. So he bought the belt from the Dandenong markets, it had raised metal studs, and he was at a McDonald's wearing the belt, just wearing it, had the raised metal studs, and he was arrested. I don't think he was taken into custody, but he was charged with possessing a weapon. And he went to court and he was found guilty by a magistrate. The magistrate didn't record a conviction against him. It's something a magistrate can do. But he was found guilty of possessing a regulated weapon because he was wearing a belt. And this is a good example of legislation being drafted in broad and general terms. Hey, you just can't possess a weapon. And then the government of the day and the police decided that studded belts were a weapon. It's then up to the courts to give meaning to the word weapon, because what subsequently happened is this matter was appealed. It ended up in the Supreme Court in Victoria. And the Supreme Court looked at it, and in their judgment, they looked through it and said, hey, we need to obviously determine whether this thing should be given a weapon, should be considered a weapon. Is the government of the day saying that a belt is a weapon? Is that going beyond what the Act says? Because the Act says you can't have a weapon. And quite clearly, the Supreme Court said that a weapon, they gave meaning. Again, we talk about interpretation, meaning, giving meaning. They gave meaning to the term regulated weapon. And they effectively said a regulated weapon should only be something whose primary purpose is that of being a weapon. Its primary purpose is causing harm in some way, of which a studded belt is not. As a result, he didn't get a conviction, but his finding of guilt was quashed and he had his belt returned to him. But what we see there is a reason for statutory interpretation. The word weapon is broad and general. It wasn't defined in the Act. So then the courts had to decide what the word weapon meant. And they said a weapon is something whose primary purpose is to be used as a weapon. So that's a good reason for statutory interpretation. Another reason why courts need to give meaning, again, want to highlight that key thing, give meaning to an act of parliament, is future circumstances. Laws are often passed a really long time ago and they don't necessarily think about things that might develop in the future. And they might need to be clarified as new situations arise. A great example is external affairs. If you've done the Tassie Dams case, you would know this one. The Australian Constitution gives the federal parliament power to make laws regarding external affairs. The Constitution was written in the 1890s. There were no such things as bodies like the United Nations or the League of Nations, which preceded it. There were still empires around the world. We hadn't even, we were a long way off World War I at that point in time. The concept of external affairs when the Constitution was written was very much more about our relationship, so our affairs with the Commonwealth and our affairs with Britain as our founding nation. These days, external affairs has been found to mean, as future circumstances have arisen, external affairs is anything to do with international treaties, anything to do with United Nations, international relations, really broadly, because that term has changed over time. So we don't need to actually change our constitution. We don't need to rewrite our constitution or add a definition. We don't need to have a referendum for that because the court is just able to interpret it, the High Court, and say, hey, this is now what external affairs means because future circumstances have changed. So that can be a really, really good one to explain. A reason for statutory interpretation is that circumstances have changed, society has changed since the law was originally drafted, or the Constitution in this case. A third reason for statutory interpretation, it's a little bit similar to the first one, but ambiguous wording. So some phrases that might have multiple meanings. So we know words can mean multiple different things. And sometimes if a word means multiple different things and the Act doesn't stipulate which specific meaning they're going for, courts might need to interpret that. There's been a few, I can't remember the exact case. There was a case a few years ago around the specifics were a guy who refused to let or give the police, the Australian Federal Police, access to his smartphone. He said, even though there was a law that says basically that you have to, if you're suspicion of certain offences, you have to give them access to your computers or your computer devices, I think something along those lines. And he argued that phone didn't fall under that. And then this idea of, well, what is a computer? That word is ambiguous. A computer could just be like a laptop, like I'm working on now. Does it just mean a desktop? Does it mean things like phones that effectively are mini computers these days? And the court had to decide what the meaning of computer was in that case, considering it wasn't defined fully in the Act. And they decided that a phone was a computer for the purpose of that Act. There's also this case, Davies v. Waldron. This was a case where a guy jumped in a car, turned it on, and basically supposedly moved the car a little bit, turned it off again. Was breathoed, was found to be over the limit, and charged and convicted of driving while over the limit. The law specifically said that you're in charge of a motor vehicle if you start or drive a motor vehicle, and the guy was adamant that, well, he never intended to drive. He was just seeing if it would start because his mate said the car was stalled and wouldn't start. So he was just seeing if it would start. He never had an intention to drive. He never had an intention to take the car anywhere. Therefore, he couldn't be convicted of the offence. There is an argument, or the ambiguity there is, what does it mean to start or drive a car? Do you have to put it into gear? Is it just sitting in the driver's seat and putting your seatbelt on? If your keys are in the ignition, does that count as starting it? Do you have to turn it over? There's so many different meanings that you could get from the concept of start or drive, or being in charge of a motor vehicle. And in this case, the court found that the act of putting the key in the ignition puts you in charge of a motor vehicle. So they provided clarity there to what was ambiguous wording. So putting the key in the ignition, that's being in charge of a motor vehicle. Our fourth reason for statutory interpretation. Look, I would say that you probably want to remember two of these like really well. You probably don't need to remember four. You might pick the two that speak the most to you and the easiest to understand. And this is a little bit like future circumstances as well. The changing nature of words. And that's the fact that as society develops and changes, and particularly technology improves, which is a big aspect of this, the meaning of different words can change. And the case here, and I'll give you a good link to an article on it later, and the decision is what's called the Kevin and Jennifer case. And this is a really straightforward one. Like the Marriage Act said, or used to say, marriage is between a man and a woman. In the Kevin and Jennifer case, Jennifer was a biological woman, born a woman, lived as a woman. Kevin was also born as a biological woman. This is in the late 90s. Late 90s. 99 they got married. Kevin was born a biological woman, but had gone through gender reassignment quite a long time before they got married, had transitioned to be Kevin, was living as a male, had surgery, so was post-operative to transition to being a male, was recognised as a male in all aspects of society. So Kevin and Jennifer got married, and the Australian government at the time challenged the validity of their marriage and said Kevin's not a man. Marriage has to be between a man and a woman. Kevin's a woman. And this speaks to the changing nature of words. The meaning of words changes. When that law was written, and the Marriage Act was written in 61, the man and the woman part was put in the 90s, I think, if I remember correctly. But it was much more straightforward. What is a man and a woman? Technology around, post-operative, etc., hadn't really developed at that time. And then by the time this case comes up, it has. And the judge has to decide in that case, and eventually the full bench of the family court had to decide what was the meaning. They had to give meaning to the word man, because what was a man had changed. And in that specific case, the full bench of the family court found that particularly being post-operative, meaning that Kevin had had surgery to transition to being male, and the fact that Kevin was living as a male. This is all evidence that Kevin had to produce. The fact that Kevin was living as a male, had surgery, and was post-operative meant that for the purposes of the Marriage Act, Kevin was considered a man. So man now means, or at that point in time, because the Marriage Act has changed to allow same-sex marriage now, at that point in time, the meaning of man in the Marriage Act was someone born a man, a biological male, but also someone who had undergone gender reassignment surgery to become a male and live as a man. So that's an example of the changing nature of words, and as a result, the court needed to give meaning to that word to apply it to a case in front of them. So, what are the effects of statutory interpretation? So, all these cases I've just talked about, there's then ongoing effects of those. Well, first of all, simply the words were broad and general, they were ambiguous, their nature had changed. Well, after statutory interpretation occurs, those words now develop meaning. So that meaning, that greater clarity around what the words means they can be better applied to situations in front of them. So Dang v. Tiroler, he can no longer be found guilty of that studded belt because a studded belt does not meet the definition or the meaning of regulated weapon. So words develop specific meanings. precedents developed. I'll talk about precedent much more in our next video, 4.1.8. But from now on, particularly when that interpretation is done by the higher courts and the highest court in some cases, that's the meaning until Parliament changes it, if they do, which we'll talk about in a moment. So the Act of Parliament and then the interpretation by the court, those two things are combined together to become a complete law. So no one else wearing a studded belt in the future can be charged with possessing a regulated weapon because the meaning of weapon has changed. Other post-operative transsexual males could get married to women after the Kevin and Jennifer case because that is now a precedent and that is now the meaning of the Act. The Commonwealth can legislate in areas of residual power if it is related to a treaty that they have signed, because that is the ongoing meaning now of external affairs, because you look at the interpretation and the law together. So precedent is developed, the law becomes more complete, is an effect of statutory interpretation. Number 3 and 4 are very much combined. And again, I'd say that you would need to learn or remember probably 2 of these. I really like this one. One can be a little bit vague. Like I'd probably look at precedent is developed and then some combination of 3 and 4. And that's the fact that Parliament is still the supreme lawmaking body. So if Parliament likes the interpretation that the courts have made, they can actually confirm that, adapt it into the Act itself, and then the Act has clarity for future circumstances. If Parliament's happy with the courts, they're probably not super likely to do that because the meaning of what the courts has done is going to be read in conjunction with the law in the future. They may be more likely to do this one. If Parliament are not happy with the decision of the courts, they're not happy with the interpretation of the meaning that courts give, they can actually pass a law as the supreme lawmaking body that overrules that court's interpretation, not in the individual case, but changes the law to have a different interpretation for the future. And that's a really important aspect of that relationship between courts and Parliament, which we'll cover in video 4.1.10 as well. A key skill here around statutory interpretation is going to be this one: discuss the ability of, we'll get rid of Parliament, discuss the ability of the courts to make law. Keyword there, discuss. So we need to get to a point, and there's factors we're going to look at in a couple of videos' time, where obviously we can have an exchange of opinions on the court's ability to make law. But it's really important to note that discussion is a higher order thinking skill. And when we see a skill in the study design like discuss, it means that all the other skills below discussion, so all the other skills below this analysis level of thinking, this higher order, they're actually open to us, which means, or open to examiners, which means even though the key skill here is discuss and not explain or outline or anything like that, we can actually still be asked those lower order questions, considering that this is a higher order skill that we've been given. So even though this skill, as I said, says discuss, we actually know that because it says discuss, it also includes words like explain, outline, etc., etc. So explain the ability of courts to make law, outline the ability of courts to make law, which means we can be open to questions like this, which is off a past exam. Outline one effect of the interpretation of statutes by judges. So just one effect of statutory interpretation, hey, it creates a precedent. You might get outline one reason. Hey, words are ambiguous. They can have multiple meanings, and sometimes when Parliament passes them, we don't know how to apply them to specific fact situations. So you can get a really basic question around this content, even though the skill that's presented is a higher order skill. This question, as you can imagine, was done pretty well, but only an average of 1.3, but 50% of kids got 2. And here's those possible responses, which are the ones that we've covered. Words or phrases are given meaning, precedent is set, and you could, in terms of the meaning given, you could talk about the meaning being extended or the law being extended or the law being narrowed. And they're really good words to use when we talk about the statute being given meaning. We can say it's given meaning which narrows which is this one here, sorry, narrows the application of the law, or it can be given meaning that extends the application of the law. Good examples there are Dieng v. Tarola studded belt that narrowed the meaning of weapon, which narrowed the application of the law. External affairs very much broadened the meaning of external affairs in that High Court case, which broadens the application of the Constitution in that case. So that's something that you can talk about in an answer as well when we talk about them being given meaning. Some links here. A newspaper article on the Kevin and Jennifer case. You should be able to access that for no cost, even though I don't think it's behind a paywall, which is good. And then I've got the Ostley decisions here for the Kevin and Jennifer case and the Dieng v. Tarola studded belt decision. Worthwhile going and having a read to see the judge's reasoning around why they interpreted the meaning of man and why they interpreted the meaning of weapon in the way that they did. Hopefully, you are very, very able to explain to someone what statutory interpretation is, why we need it, and the effects of it in an ongoing way. Thanks for tuning in. Happy studying. We'll see you in video 4.1.